behalf of CESA, I'd like to extend a warm welcome to you, our members, and to those viewers who have also joined us today for our 14th Practice Note webinar entitled Best Practice Risk Management for Consulting Engineers. It's based on our practice notes. I'll be your moderator for this webinar. My name is Wally Main, and I'm a civil engineer occupying the position of Contractual Affairs Manager at CESA. Just a quick announcement. I ask you to bear in mind that the next CESA Best Practice webinar will be held on 21 November 2023 this year. So if I may ask you to kindly diarize the date. We would like to take this opportunity as well to bring to your attention the Business of Consulting Engineering Management Development Program, also known as BCE MDP, which is an additional CESA training resource available to you. You might have seen it on one of the holding sites. The BCE MDP is the flagship of the CESA School of Consulting Engineering and encompasses much of the detail and principles of the CESA practice notes. It is highly recommended that any engineers wishing to advance their careers in the consulting engineering sector should consider registering for this program. Registration for the 2024 BCE MDP course opens on 1st of October this year. And for details of the program and the many other training courses offered by the School of Consulting Engineers, kindly click on the training heading on the CESA website, which is cesa.co.za. If you or a colleague are interested in attending the BCE MDP, you're advised to look out for the information sessions that are held throughout the year. I would also like to inform you that the webinar is being recorded and the presentations will be available after the webinar on the CESA website by clicking on the headings Guidelines and then Presentations. To access the recording of the webinar, however, simply go to the CESA website, click on the YouTube icon, and then you just have to scroll through the recordings. Before we get started, I'd just like to outline some of the house rules for you, our delegates or viewers. On the taskbar at the bottom of the screen, you will see the chat and the Q&A icons. Please use the chat for any comments you may have and the Q&A for any questions you would like to ask the presenters. So to unpack today's topics, we are very fortunate to have two knowledgeable panelists joining us, for which, of course, we thank them greatly. They will each deliver their presentations, and only at the end of the webinar will there be a separate question and answer session covering both the presentations. And thereafter, the proceedings will end with some closing remarks. The first panelist will be Francis Gibbons, who will speak on CESA Practice Note 93, which deals with identifying payment and other risks in consulting engineering. Francis is a professional engineer and an active member of the CESA Supply Chain Management Committee. He is a retired civil engineer with extensive experience and was greatly involved in the most recent revision or updating of the CESA practice notes. In addition, Francis is the chairperson of the CESA Practice Notes Subcommittee. At this point, I'd like to hand over to Francis. So it's over to you, Francis.
Thank you very much, Wally, and good afternoon, everyone. It's a privilege to be presenting in this webinar, so thanks to CESA as well. As Wally mentioned, I'll be presenting on practice note number 93, identifying payment and other risks and how to deal with them. We did a recent update to this practice note and found it to have a wealth of information, and so we added it to the webinar schedule. The purpose of this particular practice note is to provide insight and guidance on the following insofar as getting paid under your contract and dealing with other risks are concerned. So it's to do with risk identification in the tender process when tendering for contracts and practical tips to qualify out certain risks. And during the implementation of professional services contracts, what available remedies there are against the client in the event of late payment, as set out in the various professional services contracts. So obviously, it's something that CESA recommends, and I'm sure most members adhere to, is the client and consulting engineer should agree on commercial terms that set out the timing of deliverables and related payments, as well as the method of payment that seeks to balance service provider cash flow and client risk. The standard form of contracts that are generally widely used are understood by those involved in the construction industry and are generally fair to both employer and consultant. However, extra care must be taken when the employer changes these standard form of contracts, perhaps using a set of particular conditions, for example, or their legal teams draft their own set of contract terms and conditions based on the standard form contracts. These can often lead to messy situations or where the risks are a bit unbalanced and in favor of the client. So the key questions that are dealt with in Practice Note 93, there are 11 of them. It starts, who are you contracting with and what is their financial standing and reputation? In other words, how well do you know the client? What are the proposed contractual terms? Thirdly, determining what terms of the agreement are regarding payment, what the terms of the agreement are regarding payment, and what remedies are available for late or non-payment. Then, how does the agreement deal with extensions of time? How does the agreement deal with adjustments to the scope, prices, and program? How does the contract deal with unforeseen events, termination for convenience? And what is the exposure in respect of claims and impact on PI insurance? And then the third set of questions that it deals with are, what happens in the event of a dispute? What do I do if I come across an unfavorable clause in a proposed contract, or there's a clause missing that I would like to insert? And lastly, who must sign the contract? The practice note also deals with certain aspects of the PFMA and the MFMA when you are contracting with government entities. There's a few paragraphs on that at the end, but I won't be touching on that in the webinar due to the time constraints. Okay, so the first question is, who are you contracting with and what is their financial standing and reputation? So it's quite common in larger practices, especially international practices, to do third-party assessments of their clients. And this is especially true also for smaller consultants when you're dealing with mainly private sector clients, I suppose, like project developers or property developers or small-scale mining or exploration companies, or turnkey contractors who you might be contracting to on a design build contract. And obviously it's less so important on when you're dealing with a municipal client, because well, it's it's probably more acceptable to go into a tender with a municipal client without doing a third-party assessment. So then you need to establish whether the funding arrangements for the project are in place and sufficient to cover the project. And FIDIC, I suppose, because it's an international form of agreement, states the client shall submit to the consultant within 28 days after receiving any request from the consultant reasonable evidence that financial arrangements have been made and are being maintained, which will enable the client to make the timely payments. So that's a very important aspect that should be checked when you're going into a tender. And if there are limited means of confirming whether or not the client is a risky business, there are mechanisms to reduce the payment risk. either through a payment guarantee, very unusual in the South African circumstance that a client would give you a payment guarantee. And but another way is to try to negotiate cash positive payment terms, where you are being paid in advance of the work being done. Also, not that common in South African government contracts, shall I say, but more common on international, World Bank, and sometimes in the private sector you can arrange this. Sometimes it requires that you provide an advance payment guarantee, which sometimes negates some of the advantage of having a cash positive cash flow. But also having a cash positive payment terms is not much good if you don't also have the opportunity to suspend your services when the cash flow goes negative. So, but that's something we'll discuss in one of the later questions. So, question 2: what are the proposed contractual terms? They're commonly used in South Africa. The CESA Model Professional Service Agreement, the 2021 edition, is now available. The FIDIC White Book, the 2017 edition. Then NEC 4, which is also a 2017 edition, and I think NEC 3 is sometimes used as well. The CIDB Standard Professional Services Contract, which hasn't been updated since 2009, and the PROXA Agreement, which was updated also in 2021. But as I mentioned earlier, it's essential to check particular and special conditions as set out in the contract data by the client, as these may change some of the clauses quite substantially. So a lot of the government entities use the CIDB practice notes, form of agreement rather, because that was in the standard for uniformity in construction procurement. But it's worth noting that as of the 2019 edition of the Standard for Uniformity in Construction Procurement, there's no reference to standard forms of contract for professional services contracts. So there's no requirement under the SFU of 2019 to adopt either a CIDB or an NEC or any other professional services agreement. It is quite open. So if you do have the opportunity to influence your client, then we would suggest you opt for the more recent model forms, and probably I would advocate the CESA model form of agreement as the best. And we'll see why in the following slides. Okay, what are the terms of payment? Obviously, the very important part of the agreement. The agreement should specify the value of the consultant's remuneration, how and when such remuneration will be paid, and what steps will the consultant be able to take if he is not paid on time. Okay, now we'll go through a number of slides dealing with the various risks that show how the various forms of agreement deal with aspects of these questions. So in the first one here, does the contract allow for interim payments? And yes, they all do. And what is the frequency of interim payments? Well, that's monthly in CIDB and PROXA and CESA form of agreements, but in FIDIC it needs to be spelt out in Appendix 3, and in the NEC it needs to be spelt out in the assessment interval needs to be specified. It is not there automatically. So, and then the time for payment of invoices, CIDB 30 days, PROXA on receipt, FIDIC 28 days, NEC 4, of course, is a little bit more complicated. The service manager first assesses each payment claim within a week of the assessment date. The consultant then invoices within a week of the assessment. The employer pays within 1 week of the invoice, or 3 weeks after the assessment date, whichever is later. And CESA has 30 days. Then if there's a disputed invoice or part of the invoice is disputed, is there a clause that deals with this? So in CRDB, yes, notice of dispute must be given before the due date of payment. Similarly for Proxa and for FIDIC, yes, 7 calendar days notice must be given of the intention to withhold and with reasons given. NEC4, no, there's no clause that deals with how to dispute or how disputes are handled, because it's done by the service manager from the outset. You can refer dispute about the assessment of their final amount due within 4 weeks, but interim assessments need to be treated as any other dispute in NEC4. And then finally, under CESA, you've got 4 days. The client must give you 4 days notice prior to the date on which fee payment becomes due, with reasons, but not delay payment on the remainder of the invoice. Okay, so then we come to the big topic. What are the remedies available for late or non-payment? So firstly, on a legal viewpoint, failure to make payment in accordance with the contract is a breach of contract. The aggrieved party then becomes entitled to one or more remedies prescribed, either in terms of the contract or alternatively at common law as a result of the other party's breach. And our law and most breach provisions and contracts oblige the aggrieved or innocent party to give notice of breach to the other party. So what are firstly, the remedies are interest claims and then suspension. So if the client pays late, is there a clause that entitles the consultant to interest? So under the CRDB, under the Proxa, and under the CESA, there's the normal prime plus 2% calculated from the due date for payment. In FIDIC, the rate of interest must be set out in the Appendix 3, and in the NEC, the interest rate must be set out in the contract data. There's often a reluctance to charge clients interest, but certainly it is recommended because it creates all kinds of what shall I say, concerns within the client body, as any interest invoicing must be treated as sorry, what's it called, expenditure, a fruitless expenditure. So and then it has to be explained. So if you are able to claim interest or put in an interest invoice, it does put attention onto your invoice and perhaps give it more priority in terms of getting payment. Okay, now if the client pays late, is there a clause that entitles the consultant to suspend the services? And this is available under the Proxa, the FIDIC, and the CESA forms of agreement, but unfortunately not under the CRDB, which is where most of the government or municipal clients' contracts lie, and where most of the late payment problems arise. So, and also it's not available under NEC3. So we'll come back to that, but certainly what is the notice period required if the consultant desires to suspend the services for late payment? So in the Proxa agreement, you must first issue a breach and then allow 14 calendar days for the client to remedy the breach, so to make the payment. Under FIDIC, you must give 7 calendar days notice, but the employer should not have issued a notice stating the reasons for non-payment. And then under the CESA, there's no notice required. You can immediately suspend if not paid within 30 days from the due date for payment. So that's quite advantageous. So there is a practical tip that's given in the practice note here, and it says if you are worried about upsetting the client when enforcing your contractual rights, Remember that it is the client that has given you the contract to sign, and in so doing has given you the remedies available to you in the contract. If the relationship is on good terms, there's no harm in phoning the client to advise him of what's coming if you are going to send him a notice of suspension. So then, is there a right to terminate on non-payment? And of course, in all of them, there is. So that is a very important clause for you if you are battling with getting payments made. Under CIDB, it's there. And apologies. Sorry, hang on a second. Okay. So under CIDB, there is 45 days to give notice of termination, and what you're hoping that will do is to stimulate the client into paying the invoice rather than allowing you to go through with the termination. Under the PROXA, the consultant must issue notice of breach and allow 14 calendar days for the client to remedy the breach. Under FIDIC, service need to have been suspended for more than 42 calendar days, so already under the previous suspension clause, and the consultant may then give 14 calendar days notice to terminate. And then under NEC 4, 13 weeks after the due date for payment, which is quite lengthy, although NEC 3 allows 8 weeks from the issue of a notice to the employer that payment is overdue. And under CESA, 30 days notice to terminate if the agreement if not paid within 30 days of the due date for payment. So they are all there, and again, it's not something you want to use, but it can be used as a threat to force the client to pay. Hopefully, if they are in a position to, rather than you terminating the contract. Okay. How does the agreement deal with extensions of time? The reasons for delay and disruptions to such time for completion may be classified in 3 groups. Obviously, events caused by the client or contractor, events caused by the consultant, for example, late issue of drawings, or events or persons causing delay for whom neither the client nor the consultant are responsible. And we'll discuss these in the next slides. So if the client delays the consultant, is there a clause that entitles the consultant to an EOT? So yes, in general there is, except under PROXA, there's no specific clause dealing with extensions of time resulting from a delay caused by the client. Under the CRDB, Clause 391 lists the events which might give rise to a change in the period of performance. And under Clause 392, the service provider is required to submit proposals to change the contract price or period of performance period for completion within 6 weeks. Under the FIDIC clause, Clause 4.4 deals with delays and lists the causes for which the consultant would be entitled to an EOT. And Clause 4.3.3 requires that the parties promptly give notice of any specific actual or probable future events or circumstances which may adversely affect or delay the services. Under NEC, Clause 60 lists 16 events which are compensation events, including a change to the completion date or meeting a key date, and for which early warning needs to be issued. The clause numbers are given there, and the consultant must notify a compensation event within 8 weeks of the event occurring. In CESA, Clause 4.9 lists the causes for which the consultant may request an extension of time. The consultant is required to notify the client timelessly where an extension of time becomes necessary. So some of these time periods within which the consultant has to notify the client are a bit vague. Timeously might be interpreted in different ways. So it's always preferable to have a fixed period. So like 8 weeks in NEC3, 6 weeks in the CIDB. And again, a clause like the parties promptly give notice is also open to interpretation. So not the best. All right. How does the agreement deal with adjustments to the scope and prices and program? So in other words, variations. The first thing is obviously sometimes the agreements don't deal with additional services as defined in accordance with the CESA guideline. The agreement on such additional service and remuneration should be in writing and if possible concluded before such services are rendered. So you would really like to get, if you are going to claim as on an CESA fee project, you're going to start claiming time-based fees for additional services. It's best to get that agreed in a VO beforehand. And similarly, the CESA guideline makes provision for the consultant to provide additional services relating to mediation, adjudication, arbitration, and litigation, and those should be especially dealt with in a VO, so that the rates that you're going to charge and the amount of time and the extent of work involved should be subject to agreement beforehand. Okay, are there variation clauses in the various forms of agreement? Yes, there all are. What are the notice requirements for variations? So under CIDB, it's 6 weeks from becoming aware of an event. Under PROXA, it's there's no notice requirements. Under FIDIC, as soon as reasonable, as soon as reasonably practical, and there's a 14-day notice, 14-day period for the consultant and client to agree on the impact of the variation. And if you can't agree within that time, then the client may still issue a notice for you to commence the work. Under the NEC3, if the service manager instructs a change to the scope, they notify the consultant that the instruction is a compensation event, and the consultant must notify the service manager within 8 weeks of becoming aware of a compensation event. And then under CESA, the consultant is required to give written notice to the client on becoming aware of any matter which may change or has changed the scope, cost, or timing of the services or the works. Again, so no fixed period there. And then what are the notice requirements for increasing the contract amount or time period for performance of the services? So that's 6 weeks for CIDB, nothing for PROXA, as soon as reasonably practical for FIDIC, 8 weeks from becoming aware of an event for NEC, and non-stipulated. Consultant makes a request in the CESA document. Then, is there a price adjustment clause for inflation? So yes, there is one under CIDB, yes under FIDIC, yes under NEC3 if option X1 is selected, sorry, under NEC4. And come back to the FIDIC, it only if so stated in Appendix 3, the remuneration and payment appendix. And under CESA, none unless specified in Appendix 8.2, and under PROXA, nothing. But a CPA clause is important for time or lump-based fees contract, which extend over more than 1 year. But generally, with percentage fee-based projects, CPA clauses are not necessary, as the fee is escalating with the CPA being applied to the contractors or the construction cost. So because you're getting fees on the construction costs, and that's being escalated with the CPA formula, in the construction contract, you are getting compensated for CPI, but generally that'll only be for stages 5 and 6. So just to be aware of that. All right, question 7, how does the contract deal with unforeseen events and termination for convenience? So exceptional events or force majeure, they're called exceptional events in FIDIC. So when using a bespoke contract, so one that's been prepared by the client, ensure that the contract has a suitably worded force majeure clause, which identifies all occurrences that will be regarded as a force majeure event. And and very important, in the wake of the current construction mafia disruptions on site, it's good to ensure that force majeure clauses includes business forum disruptions as a force majeure event, because that is something that you can do nothing about. In addition, there should be a requirement to notify a force majeure event within a period of 7 days of its occurrence, and where this event exists for an extended period, say 60 days or more, and if there's no end in sight, there should be a provision to terminate the agreement. Secondly, reductions in scope of supply or termination for convenience. So often employers and clients like to have the right to cancel contracts for convenience or to reduce the scope thereof in their discretion. This type of clause is found in contracts, however, the right of the consultant to any benefits under the contract, such as getting paid costs incurred in anticipation of completion of the whole of the works, or getting the 10% of the full fees on the project under the CESA clause 4.2.10. These clauses are often removed, so there's no additional fees due to the consultant if the client wants to terminate or reduce the scope of the contract. So coming into the agreements regarding force majeure, does the contract include a force majeure clause? So the CIDB, yes, not in breach, provided the other party has been informed as soon as possible. So the party is not in breach, provided the other party has been informed as soon as possible of force majeure. Yes, in PROXA. Yes, in FIDIC, although it's termed exceptional event rather than force majeure, and notice shall be provided within 14 days of becoming aware of the event. Yes, in NEC4, and yes, in CESA. Does the contract provide for payment once a force majeure has been notified? And again, all the agreements provide for that. So in CIDB, it gives the clause number 8.3.3, clause 17.5 under PROXA, and then the other also clauses given there. And is there a provision for termination under CIDB? Yes, if it lasts for 60 days or more. Under FIDIC, yes, if the suspension's lasting more than 168 days. Yes, for NEC4, but only at the option of the employer. And yes, in CESA, both by the client and the consulting engineer. So both parties can terminate there. All right, then what are the various clauses on limitation of liability in the forms of agreement? Does the contract include a limitation of liability clause? CIDB does, but it's worded quite strangely. It's the limit of liability is either the sum insured in respect of the insured events. So in the contract data, the CIDB makes provision for stating the sum insured, which is the amount of PR insurance you're required to carry, and so it's up to that sum. If the if it's an insured event, and if it's not an insured event, it's a sum stated in the contract data or an amount equal to twice the fees payable to the service provider. So just something to be aware of there under CIDB, that you watch for what is the requirement for the sum insured, that it's not out of kilter with perhaps a figure like twice the fees. So you don't want them to be asking you to provide 10 times fees cover on in your insurance, because that's then the amount that they can sue you, and the it will be the it's a bit out of kilter with the twice fees that would normally be acceptable. So yes, there all are. Does the contract provide for a limit on the compensation due under the contract? Yes, as under CRDB, again with the insured amount for insured events, and twice the fees for non-insured event, or as mentioned in the contract data. Under PROXA, clause 7.2 provides that the maximum amount is as per the schedule. Where no amount is stated, then the maximum amount is twice the fees. In FIDIC, it's as stated in the schedule. Again, NEC in the contract data, and CESA, twice the fee unless the final amount is specified in the specific data. Okay, dispute resolution. You need to be sure that there's a dispute resolution clause. In CIDB, there's a 4-tier approach. So that's settlement. I read that as amicable settlement, mediation, adjudication, arbitration. PROXA is mediation and then arbitration. FIDIC is amicable dispute resolution, adjudication, then arbitration. NEC 4 under the W1 option provides for a 3-tier approach: amicable settlement, adjudication, and then referred to the tribunal. And CESA is a 3-tier approach comprising amicable dispute resolution, mediation, and then arbitration. What is the time period for providing notice of the dispute? And in most cases, there's no time period given, except in the CESA document when you want to go to arbitration. There's a practical tip number 2 given in the practice note, which says the chosen dispute resolution mechanism must be suitable and allow for real-time problem solving. Be careful of arbitration clauses that refer to appointment of 3 arbitrators, as this is hellishly expensive and often not actually needed. And also a clause that refers to an arbitration in terms of the International Chamber of Commerce rules, often out of reach of South African businesses in terms of expense. So be careful of those. All right, question 10, dealing with unfavorable clauses in a proposed contract or when there is a clause missing. So what do I do if I come across an unfavorable clause in a proposed contract and there's a clause missing, or there's a clause missing that I would like to insert? And of course, the answer is qualify your proposal. A qualification to a client's contract is simply a way to respond to the client's request for the proposal as a counter offer, and certain terms and conditions that request for tender. Sorry, I didn't read that well. Qualification to a client's proposed contract is simply a way to respond to the client's request for tender as a counter offer. Now, I'm sure that we'll get some discussion about this in the Q&A, and mostly it's not, well, clients don't allow you to provide anything that's can be seen as a qualification. So it's sometimes it can be worded slightly differently, saying, you know, you could provide for, say we've based our fee on such and such a not qualification, don't call it a qualification, but such and such a condition, and hope that gets through into the final contract. But it is a difficult thing to handle. Where you can qualify and there are terms that you don't want to accept, then you should do. I think Sanral is the other problem client at the moment with regard to unreasonable terms, but I'm not particularly familiar with them at the moment. All right. Then the final question is, who must sign the contract? I think in the case of the consultant, signatories to the contracts on behalf of companies are required to have the requisite authority to sign such contracts, and most of the government tenders and client bodies require you to submit that with your tender. But obviously the same would apply to signing of any amendments to the contract. Ensure the contract is properly signed by the parties who are duly authorized to represent the entity in question. But it is imperative also to establish the person with the necessary authority to represent the client, not only with regard to signing of the contract, but also in respect of making necessary decisions, issuing of instructions, etc., under the contract. You don't want to get into a situation where you've been accepting instructions from someone that possibly have cost implications on the project, and to find out that they do not have the authority to bind the client to those instructions. So the authority should be confirmed in writing to avoid any issues further down the line, as I say. All right, so I'm coming to the end now. As I mentioned at the beginning, PN 93 also has a section on entering into a contract with a state entity and highlight some of the MFMA and PFMA regulations which can create problems in consultancy contracts. For example, under the MFMA, if you are a consultant involved in the preparation of draft scope of services for the municipality, you're sometimes precluded from participating in the tender. If you are awarded a contract subject to the conclusion of the Section 33 of the Municipal Finance Management Act, where the contract extends over, excuse me, over a period of a few years, and perhaps extends over the 3-year budgeting period, then your contract does not become effective until the process has been followed and approval has been obtained by the client. And so failure to comply with these may put your appointment at risk. And that is the end of my presentation. So thank you very much, and I will hand you back to Wally. Thank you.
Thank you very much, Francis, for your enlightening and very interesting presentation, full of practical tips. And just judging by the number of requests for the slideshow, I think a very useful reference presentation. Anyway, your presentation provides useful guidelines, etc., for members on how to deal with identifying payment and other risks in consulting engineering. Just like to remind the audience that CESA tries hard to empower its members with useful information or guidance through its practice notes and through webinars such as this one. So this is just one of the many benefits of CESA membership, and we encourage all engineering practices to consider applying for CESA membership. Just to say that our practice notes are reserved for members. But just so if you would like to have access to our practice notes and so forth, you should really consider applying for membership, because there are many other benefits as well. So if you are interested in CESA membership, you kindly requested to contact Ms. Gillian Wands, our membership administrator, at 011-463-2022 or gillian@cesa.co.za. Okay. Move on to our second panelist, who is Ms. Sam Varela, who will address us this afternoon on the topic professional indemnity and claims for consulting engineers. Sam is an admitted attorney and a senior legal risk advisor with our affiliate, with the CESA affiliate Aon. And Sam is also an active member of the CESA Quality Risk and Sustainability Management Committee. Sam is well known to the CESA membership and was extensively involved from a legal and risk perspective in the recent revision and updating of the CESA practice notes. Sam's talk will be based on several relevant practice notes, and I'd like to hand over to Sam at this point. So it's over to you, Sam.
Good afternoon, everyone, and thank you for that lovely introduction, Wally. It's an absolute pleasure to be joining you today. So I hope everybody's got their coffee ready and that they're ready for a closing interactive session on some of these practice notes that we've just had a look at and gone ahead and put together this talk on, because they really do have some important relevance for risk management and for risk mitigation. So without any further ado, some of those topics that we're going to talk about and delve into today are first and foremost what we call understanding the nature of professional liability and how a professional can actually be held liable, how they can be sued, and what the nature of those risks that stem from that are. The next one is what to do, some of the tips and tools and guidelines on what to do when you're faced with a professional indemnity claim. So what are the steps and tools that you could sort of follow and employ when something like that does happen? I'll then chat to you about what we call an engineer's liability for negligence, and then just some further information, some further tips and guidance on how to deal with professional indemnity claims. And then I'll close with talking about the legal risk management services, which is really my team's speciality. It's what we do here at Aon, and it's the service offering that we give to our clients in terms of risk management and risk mitigation. So our practice notes that we're speaking on today, specifically, you'll see there on the right-hand side of the screen are practice notes 11, 12, 14, 15, and 43. So if you want to go and have a look at those later on the website, they will be there once those have been uploaded and updated. But this talk obviously won't be a word-for-word repeat of those sort of practice notes. It really is just a summary, but more importantly, highlighting some of those things that are at the forefront of these individual topics. So it's really a snapshot into that risk mitigation and risk management that's so critical to the business. So I'd like to kick off this talk with explaining to our clients what the nature of professional indemnity is, because I think it's quite a misunderstood topic in the industry, and it really is a field of insurance that is very unique and very specialist type of insurance that specifically my team specialize in at Aon. And really what this is insurance cover for your professional errors, your errors and omissions. In the United States, you might know or have heard of it being called errors and omissions insurance or errors and omissions cover. In South Africa, we call it professional indemnity cover. And how this type of insurance cover works is it's negligence-based cover for what we call positive acts. So if you're making a mistake and it's a positive act, so for example, a design error, calculation error on one of your drawings, which then unfortunately result in a catastrophic claim, a building collapse, etc., etc. So you did something positive, a positive act, you did something that resulted in that claim. But on the other side of that, we also have what we call a negative omission. And that really is where there's a duty or an obligation placed on you and you fail to fulfill that obligation. So for example, you were required to point something out to a client and you failed to do that, and that then resulted in a claim. So we call it the errors and omissions, the positive act, but also that negative failure to fulfill what we call a professional obligation. What I like to tell our clients is, there are many triggers and sort of spheres of important areas around this type of cover, in the sense that you must have given some sort of professional advice. Now, that is a very, very broad statement, because how that works is it's not only the advice that you're giving to your clients that you're being paid for, but if you're giving advice out as a professional, you know, as a favor for charity or for pro bono work, or just a genuine favor, you know, giving advice to the neighbor or whatever that case may be. You know, the first trigger that we speak about is, was any sort of professional advice given? So was it reasonable for the person that you gave that advice to rely on that advice? So if somebody comes to you and says, you know, you're a respected member of the built environment community, I know and understand that you're qualified and registered professional engineer, I'd like some advice on the redesign of my roof. And you then go and give out advice and you help them redesign that roof, even if you don't charge them. You know, one of the questions or the tests that the courts are going to use is, was it reasonable for that third party to have relied on your opinion? And by you holding yourself out as a professional and somebody relying on you because they believe you to be a professional and an expert in your area of expertise or field, then, you know, that leg of the test would have been passed. And then the next one would be, was your conduct that of a reasonable professional? And this is probably one of the key highlighting themes of, you know, the test for negligence. How does a court determine whether or not you as a professional have been negligent in your conduct? Well, how they're going to do that is they generally weigh your conduct up versus the conduct of another professional with a similar set of skills or competencies, and they test to see whether or not your conduct fell short of that. You know, that would then determine whether or not you had been negligent in a specific matter. Remember, when we talk about the negative omissions, what's so important here for me is that duty of the failure to advise. So, you know, there's legislation that specifically says to us as professionals that we have to give advice in certain circumstances. So, you know, if you're designing on a project and you know for sure that something has gone wrong on that project, I'll speak to you later on about the notification of claims. But if you fail to advise that there's the potential for harm to come out of a situation, and it's very clear to you, it can be proven that you knew about that and you failed to advise, you know, that's what we call that sort of negative omission or failure to advise. Okay, so liability for negligence and understanding the nature of how you could potentially be held liable is incredibly important. Remember, the standard of care that the court is going to use to sort of test your liability is always going to be higher than that of a lay person. You know, the courts are never going to compare the conduct of an engineer in a built environment situation to that of a lay person, because, you know, the test is just that much higher. So you will then be treated as the reasonable expert or the reasonable professional in your field and not the reasonable person test. So just some tips on, you know, managing that and understanding the nature of liability, you know, that you're exposed to. These are some of the tips that are highlighted in that practice note on liability for negligence. And the first one I speak about there is, how do you conduct your practice? It's always important to try and conduct your practice in a manner that you are anticipating litigation. Any job or any project that you're working on could potentially one day, unfortunately, result in a claim. And you have to conduct your business with that understanding that, you know, any given situation can go wrong. So we have to do all of that due diligence to make sure that if it does go wrong, even once we've employed all those risk management and technical risk mitigation techniques, you know, that you are prepared for that. Adopt work techniques which ensure that failures do not occur. Make sure that every single instruction that you give is faithfully recorded. And this really is one of the biggest take-homes for me of the presentation. Good, solid, sound record keeping is critical to the management of any business. And I cannot stress that enough. In the event of a claim, it's very, very difficult to prove a matter and to defend someone, you know, when a matter happened 10 years ago, or you originally did the design some 10 years ago, and it's just, there's just no records. And it's very difficult to go back and prove what really happened on that matter. And I'll take you through some of those details later on good, sound, solid record keeping. But this is one of the take-homes for me. Ensure that your systems of work are correctly followed by all of your staff. So this is just another one of those due diligence criteria that I suggest to all businesses. Make sure that your systems of work are carried throughout by everybody who is employed by the business, and those messages are communicated right through if you have multiple employees. Be disciplined about keeping very detailed notes of all site visits and meetings. And this comes down to that record keeping. Record carefully every conversation. Do not trust your memory, because you may be required to recollect events of several years back. In the moment, you might know very well what was going on the project, but the claim could potentially come against you in 5 years' time, and then it is incredibly difficult to try and remember a conversation that you had on site with your project manager, or with the construction team, or whoever it might be. Be very, very careful of not having a record of what was said, what was discussed, and what was decided on. Make notes of telephone conversations, record that somewhere in writing. Make a note of what was discussed when something important is said or a decision is reached. And again, that comes down to, if it ever does emanate and become a claim, and you are sitting in court on the witness stand and you are having to recall what happened, it's very difficult to rely on memory for that when there's so much detail and so much happened on a matter or on a project. So important conversations should be backed up and just notes made of what was decided. Have routine checks on how faithfully and accurately these records are being recorded by your employees. Again, you working in the business, attending the talk might employ that, but make sure that anybody working in the business is also familiar with that there's regular training provided to staff on how to make sure this is being done. And I think it's so important to give our junior engineers the support that they need, just in terms of the practicalities of working on a project. When you commence services for a client, what are the steps and the sort of minimum operating standards that need to be in place, and what is the due diligence from a record keeping perspective that you have to employ, and make sure that that's being done. So not only that training is being provided, but that it's being maintained, and that staff are being constantly reminded, and that you are checking up on that. Another important one is to keep accurate diaries and avoid casual undertakings, and have adequate communications with your clients. So I always like to say important things need to be reported in writing and put in an email, so that you can then go back and have a look at that, and then obviously backing that up. So if there is a system failure or a crash or whatever the case might be, that you then have access to that. Another important point is when someone leaves the business, if an engineer leaves the employment of the company, where are their files being stored, where they're being recorded, who has access to that, and is it being backed up? Okay, so some key tips on how to deal with professional indemnity claims and the prevention of professional negligence claims. 3 key themes that I always like to highlight for our clients are, number 1, effective communication, and that's what we spoke about on the previous slide. Then the second one is dealing with human error. And the third one is the financial implications of the project. So if I spend a couple of minutes on discussing the dealing with the human error, what's so critically important there is to keep a written diary or regular file notes of what was taking part on the project from a professional services standpoint. Develop a sound engineering judgment. And I guess this really comes from experience and sort of that good, sound, solid training and mentoring, from experienced engineers that have the expertise and really the experience to give that advice and to teach and to train. Also to avoid design and documentation delays by careful scheduling. It's so important to stick to, careful scheduling and record keeping in that sense, that, you've got a program and that you can implement that and that you can follow that. And if, you have to default from that, that you can go back and check what steps were missed and what still needs to be done. Then to resist impossible deadlines. And I really can't stress this point enough. Overcommitting in a short time frame and then having to rush and to get things out quickly, often mistakes are made in haste. So avoiding shortcuts because of those critical time delays are very, very important to make sure that you are scheduling enough time to be able to give, the expertise to the project that it deserves. And I think this ties so closely together with the financial implications of the project, because we know that on site often, unfortunately, you are put under pressure and you do have to do things quicker than you would normally be expected to do. But to the point where you are taking shortcuts and sort of trying to meet those impossible deadlines, that could be to the detriment of the project and, of course, to the detriment of the professional if mistakes are made. And when I say there, I link directly to that slide on your right-hand side where I speak about the financial implications of the project. As the engineer, I believe, and any professional working on the project, it really is so important for you to consider what the financial health of the entire team are. So are you looking at whether or not the client has the funds to pay the professional fees and to appoint the experienced professionals that are required on that project, and even the more junior members, do they have the financial standing to satisfy that? But what about also the financial health of the rest of the team? If you're appointing anyone else on behalf of that client, or there are other professionals being appointed by the client, and then contractors who will then implement your design, who is being involved and who is really carrying out the implementation of your design on that project, that is critically important. And it's good for me, to see professionals taking that into account, because that means you're considering the overall longevity and risk of that total project. Only undertake work within your firm's competence if you believe that it needs to be outsourced. Whether or not you ask the client to do that appointment directly or you want to subcontract that work out, that's a commercial decision and arrangement that has to be taken, but it's an incredibly important decision, and don't take on work that you just simply can't do. You would need upfront to confirm your scope and all of your arrangements in writing. And I always say to our clients, when you receive that scope of service, sit with it and digest it and make sure that you're comfortable with it, with that document, because ultimately it's a binding document. Don't take on liability for things that you don't want and that you can't do, because if something does potentially go wrong and you ultimately sign for that, you could then potentially be held liable for if something does go wrong on that. And then this topic is what we call the legal risk management services. And this is incredibly close to my heart. This is what my team do at Aon. We specialize in what we call the legal risk management services. And we're a team of admitted attorneys who offer the service to our insured clients who take out professional indemnity insurance with us. And I'll just spend a couple of minutes explaining to you what the nature of the service is and the importance of it, the importance of risk management and risk mitigation. So legal risk management really assists in creating general awareness of identification and management within the consulting engineering sector and the rest of the built environment, which really should reduce your liability and exposure and ultimately and hopefully reduce PI claims. I always like to explain to our clients that proactive risk management is really a vital and essential business tool. It's no longer just a nice to have or a misnomer. It's critical to any business. And having an understanding of the nature and the way that you can be sued and the types of liabilities that flow from your specific profession is incredibly important. South Africa is now sort of starting to follow global trends in that we're becoming what we call increasingly more litigious, in the sense that attorneys are offering services to clients on what we call a contingency fee or no win, no fee basis. So, where somebody might not have had access to an attorney because it was so expensive, now they could approach an attorney and say to them, well, could you take on my matter? And if you win, then you obviously take a percentage of that. And, we are seeing a development in our law in the sense that more and more parties who maybe traditionally in the past wouldn't have sued are now taking, matters to court, and we are seeing an increase in litigation, not only globally, but now specifically in South Africa as well. So professionals are now being more exposed than ever to allegations and claims for both what we call professional negligence and even misconduct. To close, I just want to talk to you a little bit about some of the leading causes or sort of matters around liability claims, some of the types of trends that we're seeing and issues in the industry that we're seeing, specifically in the claims area. And, you know, these are sort of at the forefront of risk management and, you know, what we are dedicated and committed to addressing, you know, in catering to risk management. And the first one there, and one of the most critical ones that has been a trend, you know, for the longest time, is engineers, consulting engineers signing contracts that they just haven't read and that they're not familiar and comfortable with. You know, not all qualifications made at proposal stage make their way through to the final contract. So be very, very careful of what document you're being presented with and what you're actually signing and what is finally agreed on. If there are counter offers up in the air, back and forth negotiations between the parties, be very careful around what the final documentation, you know, that's actually signed and agreed on. Agreeing to clauses that may prejudice your policies, so for example, service warranties and guarantees, you know, that could have the potential, in the absence of negligence being tested and proven against you, you know, to prejudice your claim. And then the next one is fee recovery. And, you know, this maybe links a little bit to what Francois was saying earlier on. Fee recoveries where the client refuses to pay outstanding invoices due to a claim from their side of consultant's negligence. So, for example, what could happen is, you know, your client presents you with a scope of services, you undertake to do that work, and you faithfully fulfill that obligation. And there's absolutely no negligence on your part. But for some or other reason, they just don't pay. So, you know, if we see that the client didn't have sort of the financial health or backing to pay for that project, then they potentially withhold payment of your fees. And that can be critically dangerous for the consultant because now you're in the service industry, you've obviously spent time and, you know, there's a cost to that time, you've provided a service and now you're not being paid for it. And there's no allegation of negligence. In terms of our PR policies, you know, we will assist with those matters, not from a debt collection perspective, but in the sense that if you have been accused of negligence, then our policy is triggered for that. But, you know, sort of those payment terms and conditions and clauses in your initial contracts are so critically important, you know, to understanding how the outcome of those matters will be determined. And then underquoting for a job, especially by young, inexperienced engineers, resulting in the rushing of work. And we spoke about that a little bit earlier on, you know, rushing to meet unrealistic, just crazy deadlines that would almost ordinarily be impossible to meet. Okay, and our last slide for today really just speaks to the legal risk management services some more, and, you know, some of those other sort of claims trends that we're really seeing amongst within the engineering space is doing work of contractors. So taking on work that ultimately is not the work of a consultant. So the physical construction, the implementation of designs, be very careful of that. You know, if you are subcontracting that out, the correct insurances and the correct advice and risk mitigation advice needs to be in place around that. Allowing contracts to include fit-for-purpose clauses. These are some of the types of agreements that we're seeing nowadays, very sort of unique and common to contractor type agreements, and those types of clauses will have the effect of potentially prejudicing professional indemnity cover. Appointment of underqualified professionals, i.e. subconsultants or joint ventures. You know, that is a very unique type of relationship that does carry risk and liability with it. Accepting appointments on behalf of your client, you know, appointing somebody on behalf of the client because you are either acting as the lead engineer or the principal agent or whatever capacity you might be acting in. And then giving gratuitous advice. So favors without a contract are incredibly dangerous because there's no sort of capping of the liability there. And then beware of vague or imprecise briefs given by your clients. Make sure that you're qualifying that and that you're making sure that you can and are comfortable with carrying those services out. And then changes in design during your construction phase. We know that changes are imminent and that they do happen, but make sure that that is well documented and that you are checking that and that errors are actually being checked and finalization is being met on that. And that's it from my side. So thank you to everyone for joining. Thank you, Francis, and thank you, Wally, and I hope you enjoy the rest of the afternoon.
Thank you very much, Sam. That was a great presentation and very valuable, I think. And the members will do well to remember the points you've made, and avoiding difficult claims and liability, etc. Yeah, thank you very much for that. And at this stage, I'd like to pose the questions submitted by the delegates to the panelists for their response. So that's to Francis and Sam. Okay. The first question is quite several requests for copies of the slides used in the presentations. It's a little bit difficult because some of the presentations, like Francis, are very detailed and almost give away the content of the practice note. And we are quite strict about reserving or restricting access to the practice notes to membership, because our members pay for the benefits of membership. And so we can't willy-nilly make them available to everybody. However, I think if you especially want a copy of either presentation, you're welcome to write to Gillian at CESA.co.za, and we will judge your request, etc. And particularly, I'm talking about consulting engineering firms that have chosen not to be members of CESA, that shouldn't really enjoy the benefits of membership of CESA. Clients we're willing to share practice notes with on a sort of individual request basis, because we're partners in delivery of infrastructure. So that deals with that. We had at least 5 questions or chats about that. So moving on to the first real question. I'll just read it out. In today's built environment in South Africa, implementation is often led by project managers, and cost usually overrides sound engineering judgment. For example, changes on the designed aspect of a project may only be subjected to cost and time, thus overriding the design engineer's input. Often as-built drawings find no one to sign them because of this setup. How would a failure affect the designer's PI in such cases? Would only the design be looked at independent of the implemented but tainted outcome? Sam, could you look at that?
Oh, so look, I mean, it's incredibly risky and it's incredibly onerous to sign off on anything that you haven't verified. Ultimately, when you put your pen to a piece of paper, you're accepting responsibility for that. So if something goes wrong, you will be most likely one of the parties that get called into that litigation to explain why you signed off on something if you weren't comfortable with it. Especially when you didn't do the initial design. That's incredibly risky and dangerous, because you can't sort of go back and do deconstructive testing to check whether or not something was adequate and not flawed and didn't contain any errors or mistakes. So ultimately, yes, the party who's responsible for the mistake, hopefully, that would be discovered, through investigation, through expert witnesses, etc. But you would for sure be one of the parties called into the process if you signed off on something and you missed an error, because that in itself could potentially be negligence. And I totally understand why there's sort of this fear around doing that and signing off completion certificates for things that you weren't the original designer for. It carries weight and it carries responsibility. And I always say to engineers, you know, you've got to be so careful of accepting responsibility and then weighing that up against or versus the reward that you are receiving for that. You know, sometimes the risk isn't worth the reward. And you know, it can be incredibly dangerous. So that's my my gut feel on that. But if you have some more questions on it and you want to unpick it, you're welcome to give us a call.
Thank you for that, Sam. Then another one, it's from an anonymous attendee. How does PI work for engineers in government working on minor refurbishment or maintenance projects? And these engineers are employed by government.
I'm not sure if they need to take out their own specific policies. I would presume so, if you employed by the state, but you'd have to find out from the employer. I guess you'd find out whether or not they've taken out a policy on your behalf. And if there's not one in place, then sort of what your responsibility around the work would be. Because if a mistake gets made, remember, ultimately the client or the party that could potentially be held liable would then be, you know, the state, but there would then obviously be that inquiry into whose mistake it was and what the negligence was. So I think it would be dangerous to sort of operate without insurance in place, because ultimately somebody's going to be held liable for that. And then obviously there's that sort of personal liability element. So not only the commercial aspect, but the personal liability. So, you know, if X decides to sort of investigate and determine the outcome of that, you know, that then would be a matter on its own. And then the criminal liability that could potentially flow. So if somebody's killed, culpable homicide, things like that, you know, civil liability is just one leg of the ways in which an engineer can be sued. You know, there's other areas or elements of liability that flow from the design work, or the mistakes that could happen.
Okay, thank you, Sam. Sorry, the audience seems to be gung-ho on the liability kind of aspects of the presentations. So it's a question for Sam. How would PI be looked at in a triple P project, public-private partnership project? And there's a compliment there. They say it's a lovely presentation.
Okay, so thank you. So the importance of understanding the fact that professional indemnity covers either a business or a person, regardless of where they're working. So if you are doing work for the government, if you're doing work for public procurement, if you're doing work for a private client, if you're doing work for a school, whatever the case might be, it is there to cover the professional making a mistake. If the client, your client, wants to take out their own professional indemnity cover, you can take out what they call project-specific cover, where the client takes out a policy to cover the entire design team. You know, that's one area that they could investigate. But it will all come down to, you know, who determines, you know, how they want to place that sort of basket of risks. Ultimately, my advice is, if you're an engineer providing professional services, it's a very good idea for you to take out your own professional indemnity cover. If you are a business, obviously your policy would cover that business, depending on how you take out that policy. And if you're practicing for your own account, you know, then you would take out a policy to cover that.
Thank you, Sam. Another good answer. Just to the next question is from Kaylee Folster. In terms of professional liability, how does the liability and responsibility interact between the engineer and employed PR-Eng and the consulting practice, the employer of the engineers? There's much confusion in the industry. Typically, the consulting practice has the PI in place and not the engineer, but the engineer is still the responsible professional. Okay,
so remember, ultimately that will come down to, You know, if something goes wrong, who are the parties that can get sued? And that's exactly, you know, the gist of the first question that we looked at. So you'd have your company that you're employed by, who takes the professional indemnity cover and covers everybody who works for the business. So they provide services on behalf of that business. They contract in the name of that business. And if something goes wrong, that's the business that's going to get sued. That's the civil aspect of when things go wrong. Again, there's the other legs of liability that flow. So for example, CESA, you know, if there was misconduct, would then investigate the misconduct. And if there's criminal liability or breach of legislation, you know, a person would be the responsible sort of party that would have to answer that. And that's also that answer's given that you are providing services in the name of your company and not in your own name. So if you're contracting in your own name and doing favors and sort of, you know, doing your own work in your own name and not in the name of the business, you know, that would never be covered by the company's professional indemnity policy. You need your own cover for that.
Thank you, Sam. This next question, I think.
Sorry, Wally, could I come in? I'd just like to add something to that.
Okay. Sorry.
So the thing is, let's say there's a successful claim against the company for negligence or something. I mean, then the obviously the company, in an extreme case, could take on the individual. But I mean, it would be you know, just to the extent that that they perhaps their excess or something. I mean, that would be really extreme, that they would go after the individual for their excess. But what I really wanted to say is most companies should have a proper quality system. I mean, all CESA member firms have quality systems in place where there's 4 eyes principles involved. So all the work should be checked. There should be so it should never be that there's one individual who is solely responsible for something that gives rise to a PI claim.
Thank you very much, Francis. Apologies for not inviting your comment earlier. This next question from ISIF, I think both of you could answer, but anyway. In many design build contracts, the term fit for purpose is included. With no clear definitions of what this actually means, i.e. a functional design can be deemed fit for purpose for actual use, but might not be what the client envisaged. Legally, what does fit for purpose mean? Do you want to have a shot at it, Sam, and then Francis can comment?
So generally, fit for purpose comes out of what we call the UK Sale of Goods Act, and that really speaks to the gist and the nature of fit for purpose. It was designed for, the term was designed for the selling of goods. And this industry is very, very different to that, in that we are not selling goods, we are providing services, professional services. So the intention is completely, you know, off and incorrect. Ultimately, what it means is that your design will be fit for its intended purpose. So regardless of what goes wrong, my services will result in X, Y, or Z. And if they don't, you can sue me and hold me liable for that. Now, that's very, very difficult to do in this industry because your services are unique to the type of work that you're doing and the expectation and the outcomes, the desired outcomes of the client. And, you know, it's very, very difficult to test and prove liability when you've already automatically agreed with your client that you are going to do X, Y, and Z. And if something goes wrong along the way, you will accept the full responsibility for that. Many things go wrong on a project. For example, the contractor implements the design incorrectly, or the incorrect materials are used, or the materials that are specified incorrectly, etc., etc. And by saying that something will be fit for its intended use, you can do that with a good. It's very, very difficult to do that with a service because they are unique in their nature. And for that simple reason, if liability can't be tested and negligence can't be tested and proven, which is the core gist of the professional indemnity policy, the policy won't respond, and that could result in the repudiation of a claim.
Thank you very much. Francis, do you want to add anything?
No, thanks, Wally. I think definitely Sam best qualified to talk on that one.
Okay. Then there's just a question, will there be a link to the recording of the webinar? The slides we've already discussed, but the webinar recording will be available in a matter of days on the CESA website under the YouTube icon. I just want to go to the chat and see if there's anything there for our presenters.
Wally, if I can just come in, there was a question that I wanted to answer, type in an answer, and then I pushed the wrong button, so it went to already answered, but it was from Karen Nina about what professional services consultants contract would you use with CESA GCC contracts, since Proxa was developed to work in conjunction with JBCC, you know. So I wanted to just type the response. So it's definitely the CESA form of agreement is written to work with the GCC. It has it provides for construction stage services, and so there's a very good fit with GCC. So that's certainly my recommendation.
Sorry, am I at the right one?
If you look under answered, under question and answer, there's open, answered, and dismissed. If you look under the answered questions, there's the one there.
Okay, sorry. Sorry, I'm just finding the stuff here. Get past the slides. What happens if appointed on risk where there's no info as to defined scope, budget, funds, or estimated fees? I suppose that's for both of you. But Sam, didn't you mention that in your presentation? You spoke about scope and that, or was that?
Yeah, so it's incredibly important to make sure that the scope you're being presented with is ultimately what was within your budget of providing, and that there's clarity on that. You know, what you're being asked to do versus what you're being paid to do, and what you have the competency to do. You know, is there clarity on that mandate? Because ultimately, if you're not happy with that and you've agreed to it in a document, that's a contract which is binding. So you could potentially be held liable to that. And, you know, a court could say to you, but if you didn't agree to do that, why did you sign it? And why did you agree to it? And that also ties in sort of with the financial health of the business that's appointing you. You know, do they have the capacity to appoint you and to appoint the necessary skills, expertise, etc., that's required for the project?
Thank you very much. And then this is, I suppose, how long is a piece of string? It says, please advise on the limit of liability on multi-billion rand projects.
So that's really exactly what you say. How long is a piece of string? The capping of liability is always important in the sense that you have the opportunity in a document to say to someone how much they can sue you for if something goes wrong, and how long they can sue you for. So that really is ultimately a commercial decision that you have to make, you know, risk versus reward, but also tying that into with how much professional indemnity cover you have in place.
Thanks. I think that comes to the end of our Q&A session. I've got a few minutes. I just need to do some wrapping up. But first to say that I hope all the questions have been addressed, and thank you to our presenters for doing so well with the answers. If there are any questions that weren't answered, you're welcome to email me at wally@cesa.co.za with those questions or any other questions you may have, and I will see that they are answered. I'll liaise with the presenters and so forth. And also I'd like to invite you to submit any comments or suggestions you have regarding our webinars, such as this one, with a view to improving them and making them more useful. And you're welcome to suggest topics you would like addressed at future webinars. And again, just send it to me, wally@cesa.co.za. And we've kind of reached the end of the webinar, and I'd like to thank our two panelists very much for availing of their time and for sharing their knowledge and thoughts with us. And of course, a big thank you to you, our delegates or viewers, for supporting CESA and attending this practice note webinar. Just quickly regarding the CPD, delegates registered with EXA may claim 0.2 CPD points for attending this webinar as part of our webinar attendance list. And for ease of administration, CPD certificates will be sent to delegates upon their completion of the survey. And that survey will pop up on your screen when you exit the webinar. And please complete it. It's a satisfaction survey, and the purpose is to provide us with your satisfaction ratings and feedback so that we can improve our future webinars. As a very last point, we'd like to ask members or viewers who regularly check to regularly check their spam or junk folders for CESA correspondence in case it ended up there. We'd also like to request that if this is the case, that you whitelist the email addresses that CESA uses, or domains, I think. And with that, thank you again for your attendance and participation. And I'd like to wish you a good day further. So goodbye.